folks, welcome to another edition of Take 5 Tuesday. We're continuing with our series, Everyone You Love and Everything You Have. Today we want to talk about some of the essential elements of estate planning, not the elements you might think. Okay, today what we want to talk a little bit about is one of the most common forms of title, which is joint tenancy or joint tenancy with the right of survivorship. This is very common, particularly among married couples. Typically makes a married couple feel good to be sharing assets together. But there are certain problems with joint tenancy that will interrupt an estate plan, affect both the effectiveness and the efficiency of the estate plan. Joint tenancy can create unintended errors. When I leave my assets among, say, 2 or 3 people jointly, what happens when each one of them dies is that the others take over. And essentially it's the last one standing that owns the asset. It can also create problems because we can't control the property at death. When I transfer an asset or put an asset in joint tenancy with my child and I pass away, I can't predict what will be happening in my child's life when I pass away. Will she be going through a divorce at that time? Will she be under the cloud of a creditor from a professional suit or a lawsuit, from a business suit or a professional suit? Will there have been a slip and fall or car accident? I've lost control of that property. My daughter loses control of the property because it's just dumped in her lap through joint tenancy. Joint tenancy doesn't completely avoid probate because at some point in time someone's going to own that asset. We're just skipping probate at the first death, but at the second death between joint tenants, we're still going to end up probating the asset. So we may delay probate, but we're not completely avoiding it. And joint tenancy can create unintended gift and estate tax issues. We can be wasting estate tax exemption when we use joint tenancy, particularly between spouses. We can be passing an asset that is subject to income taxes to someone who's unprepared to use the asset appropriately. We can, when we put an asset in joint tenancy, we're making a gift if that asset is not held by spouses. However, the asset will be fully included in the estate of the parent when they die. The IRS says that when we transfer an asset between generations, father and son, mother and granddaughter as joint tenants, when grandmother dies, the entire asset is included in her estate for estate tax purposes, even though we think of this as a gift. Until then, take care of yourself, take care of your family, and take care of your clients.